Good morning. The Senate Judiciary Committee will come to order. Our first order of business is to open the hearing on House Bill 2216, removing the mandatory term of imprisonment as a penalty for driving with license that is canceled, suspended, or revoked for failure to pay fines. And with that, we'll ask for a bill brief from the reviser.
Thank you, Madam Chairwoman. Good morning, committee. Jason Thompson, Reviser of Statutes Office. So House Bill 2216 comes to you via the House Committee on Judiciary, and it did pass the House 121-0. It was not amended, so it is in its as introduced form. And as the chairwoman mentioned, it does remove the mandatory term of imprisonment and the penalty for driving with a driver's license that is canceled, suspended, or revoked. The statute in the bill is KSA 8-262. The current law has a mandatory fine and the mandatory minimum 5 days of imprisonment. The bill keeps the fine, but it removes that mandatory 5 days for a first offense if the person is driving privileged to drive was suspended or revoked for a violation of KSA 8-2110. That's the statute that provides penalties for failure to comply with a traffic citation. So if you're a first offender and your suspension or revocation is because of a violation of failure to comply with a traffic citation, you will not have this 5 days of mandatory jail. Otherwise, you would. Happy to answer questions.
Thank you. Committee, questions for the reviser? Seeing none, then committee and those in the committee meeting room and following online, we do have 2 bills to hear today, and then do want to reserve some time to work bills as well. So on the hearing on this bill, we're going to limit conferee testimony to 2 minutes each, and so we can have time for questions at the end. Committee and conferees, we will reserve questions till after all 5 conferees have testified. With that, then, we will ask the first proponent conferee to come to the microphone, introduce herself. Kelly Trussell, Chief of Prosecution for City of Topeka. Welcome to committee. Make sure you turn on the microphone, please. Thank you.
Can you hear me now?
We can.
Thank you, Chairwoman Warren and this committee for allowing the City of Topeka the opportunity to come and speak in support of HB 2216. This bill in front of you today is supported by our governing body, and the mayor has submitted testimony in support of passage of HB 2216. Now, as Chief of Prosecution, I work hard at the city to provide an equitable judicial system. However, there is a reoccurring issue that seems excessively punitive for sentencing. Under KSA 8-262, the penalty for driving while a license is suspended, canceled, or revoked requires that individual that is convicted be sentenced to at least 5 days. Upon a second or a subsequent conviction, that minimum 5-day sentence is completely mandatory and may not be suspended. Now, it is important to note that driving while your license, or driving with a valid license but driving without insurance, is not a jailable offense and is only penalized by a fine. Notably, a no insurance charge is also only a 3-year look back, while a driving while suspended charge is a lifetime look back. Now, that means that a driving while suspended conviction could have years and years in between these convictions, but it still kicks into that mandatory jail time. Now, in my written testimony, I provided you with examples of cases that we had seen in the last year in our courts, and they're representative of the type of cases that we see on a weekly basis in the courts. They include people trying to pay off old fines to reinstate their license, but they're unable to do so in a timely manner. People can't afford to serve their sentences under house arrest, which is a very expensive option, and they lose their jobs because they are in jail or unable to have options to care for their children. Over and over, the courts are seeing these issues come up. Now, we have worked very carefully with law enforcement to have a narrow fix that would address this inequity. It would not require the five-day imprisonment, but only to those suspensions that are under 8-2110, which addresses failure to appear or failure to pay a fine. It would not affect any other types of suspensions.
Thank you. And we are out of time, but we will ask questions after we've heard from all the conferees. So,
Thank you.
thank you for your testimony. And if you can stand for questions at the appropriate time, that would be appreciated. Next, we will hear from Robert Anderson, Ellis County Attorney via WebEx. Please introduce yourself and welcome to committee.
Hello, good morning, Chairwoman Warren and members of the committee. Thank you for allowing me time to speak this morning. I'm the Ellis County Attorney. My name is Robert Anderson, Jr. I have been serving in that capacity since January 11th of 2021. And prior to that, I worked as a private practicing defense attorney, primarily handling court-appointed indigent clients in that capacity. I would echo, I think, all of the sentiments stated by Kelly Trussell. I would confirm that in my capacity as the Ellis County Attorney and as a private practicing criminal defense attorney prior to becoming the Ellis County Attorney, I've seen the spiral that can occur with individuals who are suspended because of failure to pay. They continue to get caught driving while suspended. There's more fines. There's jail. They lose their job. It's a cyclone they can't get out of. In an effort to keep my testimony as short as possible, I'm going to just very briefly add the following arguments as I see it, especially in the context of rural Kansas. Here out in Ellis County, Kansas, Hayes, Kansas is a very rural area. We don't really have established public transportation. I mean, there's some forms of public transportation. We have like 1 or 2 Uber drivers here in Ellis County. We have an access bus, but really public transportation is pretty non-existent. For that reason, these mandatory minimums are not a deterrent. Individuals who are driving while suspended, they're gonna, even if they know about those mandatory minimums, they've got jobs to get to, they've got kids to take to school, they're going to drive, they're going to take that risk. These mandatory minimums are not deterring them from committing those crimes. Additionally, these mandatory minimums are removing discretion from judges and giving that discretion to prosecutors. This is a driving force behind policies like mine, where we will continue a driving while suspended case almost endlessly in an effort to give them time to get their license back, or we will ultimately offer them a plea bargain whereby they can plead to, having no DL on person. Mandatory minimums certainly incentivize defendants to contest the charges against them. This can create costly litigation, more trials, things of that nature. Jailing people is expensive. These mandatory minimums, I believe, are disproportionate to the crime.
Thank you for your testimony. I hate to cut you short, but please do, if you're available, stand ready for questions if there are any from the committee when we've heard from all the proponents. Next, we will hear from Jeff Easter, Sheriff, Sedgwick County via WebEx. Please introduce yourself and welcome to committee.
Good morning, Chairwoman Warren and committee members. I'm Jeff Easter, Sheriff of Sedgwick County. I'm also the Kansas Sheriff Association Legislative Chair. Today, I'm representing the Kansas Association of Police, KSA, and Kansas Peace Officers Association. Very quickly, we've worked with legislators for a couple years and other partners on this. We are in favor of this bill strictly for folks that do not pay fines or appear in court. We will not be in favor if there's any amendment that tries to look at excessive traffic fines, no insurance, or other serious traffic offenses such as DUI, vehicular homicide, those type of, if those are thrown into this as an amendment. Again, we have worked for a couple years simply for the payment of fines or the appearance in court. Currently, right now, there's only 2 ways that courts can get people to pay fines. And one is through either suspending their driver's license or send the fines to collections. And so we believe this is a happy medium for those kind of people. And I'll stand for questions at any time. Thank you.
Thank you. Next, we will hear from John Goodyear, General Counsel, League of Kansas Municipalities. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. My name is John Goodyear. I'm General Counsel for the League of Kansas Municipalities. Grateful for the opportunity to come before you and speak in support of House Bill 2216. And Madam Chair, my remarks can be incredibly brief. Just generally speaking, the League supports efforts that are aimed at addressing those cycles of recidivism and cycles of indigency in our communities. That said, when we look at bills like this, we are wary. We want to make sure that local communities still have those enforcement mechanisms in place. So taking a look at this legislation, we believe that it does strike an appropriate balance, and it does so by removing mandatory terms of imprisonment for those individuals that are convicted of driving unsuspended if the license was suspended for failure to pay fines, failure to appear. That is narrowly tailored. It is very specific to those individuals and well poised to help those individuals that are in our state that are struggling to make ends meet. It comes from the reasoning that if a person truly cannot pay these fines and fees, keeping them out of work for 5 days isn't going to help them. In fact, it's going to hinder their ability to do so. We strike that balance by making sure that there are still means for enforcement, though we still have a fine here. Judges still can order a term of imprisonment if taking a look at the specific fact by the specific scenario. If it makes sense for jail time, they can still order it. We aren't removing that ability. We're just removing that mandatory sentence. So with that, Madam Chair, like I said, I can be very brief, but we support this legislation and would ask that when you make a recommendation, you recommend it favorably. Thank you, Madam Chair.
Thank you. Committee, we will next invite Marilyn Harp, JD, citizen lobbyist, as the next conferee. Please introduce yourself and welcome to committee.
Thank you. I am Marilyn Harp. For many years, I was the executive director of Kansas Legal Services, but now I get to pick what I testify on, and this is one of the bills that's very important to me. I've heard a couple references here to DUI and it not covering DUI. My pitch is this bill would make driving while suspended similar to the discretion judges have that you gave judges last year in House Bill 2377. Judges get to decide the length of punishment, not a mandatory on the third offense. And I think giving that discretion to the judges for these offenses is appropriate as well. Thank you.
Thank you. Committee, you also do have proponent written only testimony in your committee packet in front of you from Michael Padilla, Mayor, City of Topeka, as well as from Michael Koss, Deputy City Attorney, City of Overland Park. Before I ask for any other proponent conferees, I do see Senator Faust Godot in the committee meeting room. Are you wanting a personal point of privilege to introduce some guests? That would be great. Welcome to committee, Senator.
Thank you, Madam Chair. I do have with me today beautiful ladies in pink and green, and it is AK Day at the Capitol. And if they would stand, that would be wonderful to acknowledge them. And Madam Chair, members of the committee, I do support this bill 100%. And what the best sheriff in town, Jeff Easter, has says, I concur. Thank you, Madam Chair.
Thank you. Welcome to Senate committee, ladies. Thank you for being here today. Are there any other proponent conferees in the committee meeting room or on WebEx? Seeing none, then we will go ahead and open it for questions from the committee for our proponent conferees. Yes, Senator Olson.
Thank you, Madam Chair. And I guess this could be for the first one that testified. My question is, could we, instead of suspending the license, could we have a restricted license for 90 days until they pay the fee, or give them a chance to pay the fine? And I don't know if that amendment would be appropriate, but I'm just looking for a way. A lot of times these people, they're it's hard to pay the court fee and all the fees to give them a little time on a restricted license to go back and forth with work and get groceries or whatever, and then give them 90 days to pay that fine. I don't know if that would be appropriate or if the bill already covers that.
Thank you. And please introduce yourself again. Thank
Kelly
you.
Tressel, Chief of Prosecution for the City of Topeka. That would be one possibility, although I think that would require amending different regulations on how restricted licenses are given. That's an administrative act through the Department of Revenue. Oftentimes that is an option that is available to these citizens that have they can get a restricted license while their license is suspended. But oftentimes when it's for failure to pay a fine, those fines have accrued to many thousands of dollars, and they have to actually have enough paid down in order to have that. So you would be addressing kind of a multifaceted issue in allowing a restricted license. This bill itself would just keep them out of jail and continue to pay those fines under a suspended sentence so that they have a motivation to get them paid.
My thinking is they need to be able to go to and from work, and without having a license, you might be helping some, but not all. Just a thought.
Thank you. Committee, any other questions? And this is a lifetime look back then. If your fine was originally imposed 20 years ago because you didn't pay your administrative fees or fines. Are we talking fees and fines is my first question. And this also would apply if you failed to appear in court when ordered to do so.
You are correct on all of those points, and it is a lifetime look back. So if somebody was 19 and had a ticket that they didn't comply with, and 40 years later their license has been suspended, this is a driving while suspended conviction.
Wouldn't they know when they go get their license renewed every 4 years that they have a suspended or revoked or canceled license?
You certainly can. I think now the technology is there enough in the Department of Revenue that more people are on notice that this is occurring and when they do and to go get those renewals. But the problem becomes is prior to that, and you were working off of not necessarily computer-based technology, that those suspensions were happening way before that, and so then they've accrued.
Thank you. Senator Stephan?
Thank you. Yeah, I was curious too, as in the failure to appear. Has there been any research as to the whys of the failure to appear? And is that something you could distribute to us later?
I don't know of any particular research other than just having my boots on the ground and knowing when people fail to appear. Sometimes it's just simply they forgot court. Sometimes they were at work and couldn't get off of work in order to appear for that citation. Sometimes they didn't receive proper notice and they didn't know that they were to appear. Sometimes they just got the dates mixed up. I mean, there's a variety of reasons why people fail to appear.
Yeah. Thank you. Yeah, I would think you could easily categorize them the reasons into reasonable versus malintent sort of situations. It would really be helpful to have a grip on that statistically.
And that, to your point, I mean, that's why keep not eliminating the jail sentence option for this is not that's not what we're requesting. We want to keep the option to do that, but have it be discretionary so that on a case-by-case basis, we can address the bad actors and help those that are actually trying to get reinstated.
Thank you. Committee, other questions? Yes, Senator Gossage.
Thank you, Madam Chair. I was trying to look up, haven't we heard this bill or a similar bill this year? Or am I thinking of last year?
The revisor could probably help answer that, and the research could as well. This addresses only the current statute, if I'm correct, and Ms. Trussell as well, about mandatory jail time for driving on a revoked, suspended, or canceled license. Do I have that correct? And
It's correct if it's only addressing those suspensions under 8-2110, which is the failure to appear fines. There's many reasons for suspensions. We're not addressing any of those other suspensions.
So it is similar, but addresses a different part. It addresses the mandatory jail time.
Thank you.
Other questions? Seeing none, then thank you to our proponent conferees for your testimony and appearing today. Do we have any neutral or opponent conferees in the committee meeting room or on WebEx? Seeing none, then we will close the hearing on House Bill 2216 and open the hearing on Senate Bill 283, prohibiting conveyance of certain real property in this state to foreign adversaries. And with that, a bill brief from the reviser.
Thank you again, Madam Chairwoman. Jason Thompson, Revisor's Office. Senate Bill 283, as you mentioned, prohibits conveyance of certain real property in the state to foreign adversaries. There are 3 sections. I won't spend too much time, and then you've got a lot of conferees you want to get to. I will note for you in the bill brief, I provided the definitions that are referenced. So foreign adversary means any government or non-government person determined to be a foreign adversary pursuant to 15 CFR section 7.4, as in effect on July 1st of this year. The current list is in the CFR, and I've listed it there. There are 5 countries and 1 regime that are referenced in that CFR. If that list is amended, the bill provides that the Secretary of Agriculture would be able to adopt rules and regulations to remove a government or non-government person from that definition after giving due consideration to the risks to state and national security and economic costs and benefits of such action. So they would be able to modify that federal list through rules and regulations. Person is defined very broadly, as is entity. Those are in the bill. And then the other key definition is person owned by, controlled by, or subject to the jurisdiction or direction of a foreign adversary. That term is used in the later sections, and I've listed that definition both in the bill brief and it's provided in section 1 of the bill also. Section 2 then provides that on or after July 1st of this year, no person owned by, controlled by, or subject to the jurisdiction or direction of a foreign adversary shall purchase, acquire by grant, devise, or descent, or otherwise obtain ownership of any interest in real property parcels of 10 or more acres located in this state. There are exceptions to that provided in Section 2A2 regarding collection of debts, deeds in lieu of foreclosure, and enforcement of a lien or claim on land. So I'll just point you to those and just note there are exceptions to them. Land is required to be sold or otherwise disposed of within 2 years after title is transferred if it's implicated by this section. And then a person owned by, controlled by, or subject to the jurisdiction or direction of a foreign adversary may sell or convey their ownership interest if it was acquired prior to July 1st of 2023, but they're not allowed to sell or otherwise convey it to someone else who's controlled by or subject to a foreign adversary in violation of the section. The Attorney General is required to investigate any sale, transfer, or other conveyance if the Attorney General has reason to believe that it's in violation of this section. Real property that is the subject matter of a transaction that violates the section is subject to the Forfeiture Act, KSA 60-4101. There are a couple provisions in that act that say if a statute specifically provides and authorizes forfeiture, then that is valid, and that's the mechanism that's employed here. There might be some issue with another provision in the Forfeiture Act about the disposition of real property only in cases of a felony. And I only raise that because I know at least one conferee mentioned that, and we're aware of that. There's maybe a little cross-reference kind of amendment we might need to make in the Forfeiture Act to effectuate this. But the idea is that you can name in a statute that something is subject to forfeiture, and that triggers the Forfeiture Act. And that's what this attempts to do. And finally, I'll just say Section 3 is a severability provision, pretty common to most of you that have been around for a little while. If any provision is deemed to be invalid, it could be severed and maintain the rest of the action if the court will allow that. I'd be happy to answer questions or get out of the way for your conferees.
Thank you. I have a brief question on page 1, line 22, controlled by. Do we have definition for that in other statutes in Kansas or federal statutes or federal rules and regulations or state rules and regulations?
Madam Chairwoman, I'll just say that the rest of the definition is meant to define all of those terms. So if you meet the requirements of, 1, 2, 3, or 4 under subsection D, you would be a person owned by, controlled by, or subject to the jurisdiction. So you're either acting as an agent, representative, or employee, acting in some other capacity that triggers one. You're a citizen or resident of one of those nation states, unless you're a dual citizen, and then you're not subject to this definition. If you're a corporation, partnership, association, or other organization organized under the laws of that nation state controlled by a foreign adversary, or you're a corporation, et cetera, that is owned or controlled by a foreign
Sure.
adversary.
So it's a new definition in Kansas statute if this were to become law.
I would say this is self-contained. So you would look at whether you meet 1, 2, 3, or 4, and that would tell you whether you're a person owned by, controlled by, et cetera. And then it does use the term controlled by to discuss a corporation, for example. So you might have to litigate whether your corporation is controlled by an adversary versus incorporated in a country that's a foreign adversary or something like that. But that's not drilled down any more in the bill than what you raised. Yeah.
Thank you. Any other questions? Seeing none, thank you. Committee, we do have time limits to get our work done today. So we're going to limit conferee testimony to 3 minutes per conferee. With that, then, we will invite the proponent conferee, Mr. Charlie Dalton, Chief of Staff, Office of Chris Kobach. Please introduce yourself and welcome to committee. If you'll go ahead and turn on your microphone, that'd be great. Thank you.
Madam Chairwoman and members of the committee, thank you for having me. My name is Charlie Dalton. I'm the Chief of Staff to General Kobach. And we are grateful to be here supporting Senate Bill 283 as we think it addresses, an ever-growing issue not only facing Kansas, but this country. From 2009 to 2019, we've seen foreign land ownership double in that time period. And in fact, we are over 35 million acres in the United States owned by foreign entities, which is nearly the size of Iowa. And one of the most concerning trend lines of that is the amount of land purchased by China and their corporations. And it is clear to everyone that China is no friend of the United States, and their motivations of buying this land are clearly not pure. One of them is to control the food supply in the United States. And they've started that by acquiring Smithfield Foods, the nation's largest pork producer, and as well as swaths of agricultural land across the United States. Secondly, is to gather intelligence on our military. And recently, China purchased land directly next to a Air Force Base in North Dakota. This gives them unprecedented access to be able to surveil not only our operations, our training, our technology, our personnel, but clearly this and the food supply are threats to our national security, both short-term and long-term. Now, luckily, state legislatures such as this one across the country have taken this issue up as it emerges. But we also have 8 other states in the union that have addressed this with laws in the books. The strongest of which would be Iowa, which prohibits all foreign nationals from owning land in the state. Now, one of the beauties of having these 8 other states with laws in the books is it's shown that this will stand the test of not only the courts, but also the growing concern of reactionary from foreign states against not only the citizens of the states, but the state. And we have yet to see that in any of those 8 states. So that should quell some of those concerns that we've heard here in Kansas. So once again, we are very grateful that this bill has been brought forward. There are a few things that we would like to suggest that we think will help strengthen this bill. One of them is to not limit the bill to foreign adversaries, but rather replace foreign adversary with foreign national, as Iowa has done. There are several reasons for this, but the most important is that the bill is virtually unenforceable if it only excludes a small number of countries. The reason behind that is the Office of the Attorney General. If we were to suspect that there is a foreign national or entity controlling it, we would take this to the Department of Homeland, and they would be able to tell us if it is a U.S. citizen or a U.S. corporation, or if it is not. And if it's not, it is not clear to us, nor will we necessarily have the ability to be able to find out which nation or nationality that this actor is part of. And it's no secret that the CCP often operates through shell companies in other nations, one of which, an example of this would be a Vietnamese company, which would not be in the foreign adversaries list. We would have to have extraordinary cooperation from the Vietnamese government to find out if this was controlled by a Chinese entity or not.
Thank you. Appreciate your testimony. Are there any other proponent in-person conferees in the committee meeting room or on WebEx? Not seeing any, then want to direct committee's attention to proponent written only testimony from Brett Anderson, Republican Precinct Committee Man, Sedgwick County, Karen Hershey, resident of Kansas, and Carrie Sue Vosberg, Sedgwick County Precinct Committee Woman. With that, then, we will open it up for questions for our proponent conferee at this time. Yes, Senator Corson.
Thank you, Madam Chair. I think we need to be really cautious when we're acting in this space. You know, throughout history, we've seen things like signs that say Irish need not apply. There was a time when Catholics were thought by some to be more loyal to the Pope than to America. In my area, in Kansas City, we've seen an unfortunate history of redlining and restrictive covenants, which prohibited Black and Jewish families from owning homes in certain neighborhoods. More recently, in 2022, we saw a 339% increase nationwide in anti-Asian hate crimes compared to 2021. So my question is that at a minimum, shouldn't legal immigrants like visa or green card holders be able to purchase farmland and other property?
Thank you for the question, Senator. I think that the intent of this bill is to target those foreign entities and agents that are looking to pose a threat to the United States. And, this allows also the provision of the 10 acres allows for, green card holders, legal immigrants of this country to be able to live here in the United States and pursue different, forms of employment or, living here and existing in the United States legally.
So they can live here and exist here, but my question was about property ownership. Shouldn't they be able, just like anybody else, if you're here legally as a legal immigrant on a visa or green card, be able to purchase farmland or any other property?
Well, they have, and there are many things that legal green card holders and legal immigrants have access to that citizens of the United States do not, such as voting, and there are plenty of other rights where if you are here legally, you don't have access to. And this is something to protect the national security of this country.
So your contention is property ownership should also be something that they don't have a right to.
That's not what I'm trying to address with that or contending here.
It's what the bill addresses. My other question on China. So we talked a lot, or you talked a lot about China. China, I want to be clear with the committee, China holds less than 1% of foreign held acres. Most of it is owned by Canada. So I'm a little bit confused about the focus on China when they hold less than 1% of all foreign held acres.
So that stat actually comes from where is it here? Excuse me. So it's actually been proven that so that's from the USDA, and they have not shown an ability to effectively track all the land purchases. Granted, Canada does own the majority of it. But the growing concern here is the threats to national security, and I think that's something worth weighing in on.
And so this is the only bill.
Last question, Senator.
Last question. This is the only bill I've seen this year that has a severability clause. In my 3 years here, generally I've seen that when we think that we're doing something that may get struck down in court. So this is the first bill that the Senate Judiciary Committee has seen this year that has one of those clauses in it. The Kansas Livestock Association, the Kansas Farm Bureau, in their written testimony have both raised constitutional questions about this legislation. So can you talk about why we need the severability clause and which sections you think might be unconstitutional or might be likely to be struck down?
I don't think that there's any that are likely to be struck down. I think that we've seen this in the other 8 states, including Iowa, who arguably has a more restrictive or stronger bill than what has been proposed so far, and it has stood the test of time with the courts.
I take it that we can get rid of the severability clause, then would be your position that we don't need it.
That would be up to the committee.
Okay, thank you. Thank you, Madam Chair.
Thank you. Quick question. Is the federal Congress doing anything to address this issue?
I believe that the Kansas delegation has introduced a bill. I could get you in the committee the exact language and bill.
Thank you. And one other quick question. You've mentioned 8 other states have enacted a law on this issue. What's the longest that one of those laws has been in place?
So I believe the longest
Or the oldest bill?
The
bill
oldest
statute.
would go back to Minnesota, and I can get you the exact date, but it's been, I believe, over at least 1 decade, if not 2, that they've had it on the books.
Thank you. Committee, we do have time limits, so let's thank you very much for your testimony. We will now ask for opponent conferee, Mr. Aaron Popelka, Vice President of Legal and Government Affairs, Kansas Livestock Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I'm Aaron Popelka, and I'm with the Kansas Livestock Association. I want to start today a little bit explaining in its current form, we're opposed to this bill. We think with a slight change, we could get there. But I want to highlight some of the significant concerns with this policy as it stands. I think first off, we have to understand that modern agriculture is diverse and gets financing, whether it's equity or debt financing, from a variety of sources. I think initially, in the initial review of the bill, some issues were brought up about what's controlled mean, and it's not defined. And I think when we get into this, especially when we get into, I think in the proponent's testimony, they referenced some of the exclusions for debt. And we have to do that because there may be banks that have even a minority ownership. But overall, as a general matter, our policy is in favor of the free markets. And we have significant constitutional concerns with this bill. I'm an attorney, and I like to give citations, and I get to do that in front of the Judiciary Committee. And I provided a citation to the Drake Law Review out of Iowa, which has one of these laws. And this passage that I'm going to read for you is actually about that law. The challenge here is these often aren't challenged. There's only a handful. But think about it. The folks who this is impacting aren't here. And if they're not here, it's hard to challenge it. But this is what the Drake Law Journal said. Similarly, a dormant aspect of the Foreign Commerce Clause is recognized, though not as thoroughly developed as interstate variant. A facial discriminatory statute like the land ownership restriction at issue would be per se invalid if any non-discriminatory means could be employed to achieve the desired end. That means that this bill in its current form likely does that. And I think we have to think about that. It's not to say that we shouldn't be concerned about foreign adversaries, but the Constitution says that Congress is the appropriate place to do that. And to that end, my association and our national affiliate has supported Senate Bill 68, which was introduced by U.S. Senator Tuberville and is currently sponsored by Senator Marshall from Kansas. That bill places the Secretary of Agriculture on the Foreign Investment Review Board and adds ag land and transactions to the review process, which we believe is better than an outright ban given the complex nature of markets. The other thing I would note is that I think it was stated most foreign land in the United States is actually held by Canadians. So to the point that the proponent brought up, that they want an amendment to ban all foreign ownership, that would be significant. We're talking about banning allies of the United States in North America from owning land here. You have to expect, and we have members that own land in other countries, that allies would have similar reactions. That is not good policy. We also would oppose any attempt to delete the Secretary of Ag from adding or deleting the foreign adversaries in this bill. And that's because the foreign ag or the ag secretary gets a report. Finally, I want to mention the amendment that we would ask. The 10 acres issue is a significant issue when you're talking about the constitutionality. But what we're saying is,
We'll need to wrap it up. It's
Okay.
been 3 minutes, and please stand by for questions, though, if you can remain. That'd be great.
you want me to summarize the amendment quickly?
I think we have it in the written testimony,
Okay.
so we can take a look
Thank
at
you,
that
Madam
and then
Chair.
follow up for questions, which we will hold till the end of the opponent conferees. Thank you. Appreciate it. Next, we will hear from Ashley Garr, Kansas Land Title Association. Please introduce yourself and welcome to committee. You'll need to push the button. There you go.
Thank you. I'm Ashley Garr from the Kansas Land Title Association, known as the KLTA. We, as an association, consist of title insurance underwriting companies, title insurance agencies, and abstract companies and their employees. And what we specialize in is the orderly and secure transfer of real estate in the state of Kansas. We protect lenders and buyers from financial loss that results from defects in title. Our issues with this bill can be summarized. Basically, it's incredibly broad and expansive. And because of that, it subjects an unknown amount of Kansans to the penalty of forfeiture that does not have within our forfeiture laws a very consistent exemption for bona fide purchasers for real value. So going through those briefly, of course, we've talked about the definition of person who could be controlled by a foreign adversary is incredibly broad within the bill as it's written. It would be impossible for our title insurance professionals to safeguard against that. 100% impossible. We do not receive that kind of information when we get LLC operating agreements, resolutions from boards telling us who has an authority in a transaction. So we would not be able to safeguard against this whatsoever. Again, on the parcels, this prohibits ownership or any interest in real property parcels of 10 or more acres located in the state. That's incredibly unclear. Is that 10 or more acres that are contiguous? Is that 1 acre in western Kansas and 9 acres in eastern Kansas? Could it be contiguous but split into different parcels and not fall within this? And so it's not really clear that even the intent on the 10 parcels would be applied as it's intended. And finally, on the penalty provisions within the Forfeiture Act, which really it isn't consistent that the proper safeguards could be applied to Kansans. So there is an exemption within the Forfeiture Act for good faith purchasers, so that they would not be subject to forfeiture because of the acts of their seller that they were unaware of. However, within the Forfeiture Act, further down, it states, notwithstanding that subsection, property is not exempt from forfeiture if the owner or interest holder acquired the property with reason to believe that the property was subject to the forfeiture under this act. What does that mean? How would that be applied? And going through this proposed bill, regardless of intent, litigation comes to my mind over and over and over during these different provisions. Who would fall under it? What parcels would fall under it? And how would the Forfeiture Act be applied? It's really unknown. And because of those unintended consequences in the application, the KLTA does oppose it as written. We do have some suggested language within my written testimony that would make us more comfortable on some of those issues. That suggested language would be, no person not subject to this section shall be required to determine or inquire whether another person is or may be subject to this section. No interest in real property shall be subject to forfeiture under subsection E if the owner or interest holder acquire the interest after a violation of subsection A by another person and without actual knowledge. We think that there needs to be better protections within this bill for people who do not have actual knowledge because our Forfeiture Act just doesn't do it.
Thank you.
Thank you.
Are there any other opponent conferees in the committee meeting room or on WebEx? Seeing none, then we will open it up for questions for our opponent conferees, and we'll try to keep it brief. But are there any questions for our opponent conferees? Seeing none, then we will invite neutral conferee John Donnelly, Kansas Farm Bureau. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. I am John Donnelly. I'm here today on behalf of Kansas Farm Bureau. After hearing the proponent's testimony, this is probably going to be some of the strongest neutral testimony you've heard in a while. We've been working with the Attorney General's office on language such as this for quite a while and have been trying to get to a place where we could be neutral. We were close on the House They also, on the House bill that was heard, which is very similar to this legislation with the exception of the 10-acre limitation. But through this entire process, the question I have is, what is the policy we are trying to promote in the state of Kansas here? And I'm asking that as a rhetorical question because I have yet heard the answer. I've heard multiple answers. I've heard this is a national security issue. Actually, I'm sympathetic to that concept. However, if it's a national security issue, why did the Attorney General's office want to insert a less than 10 acres language when less than 10 acres could be bought right by Fort Riley? There goes that argument. This is an issue of food security, and Smithfield Foods was mentioned in there. Well, guess what? Smithfield Foods has a plant in Junction City. You know what city what fort that's by? Fort Riley. Once again, I don't think the policy is truly being forwarded in this legislation. If we want to go to the policy aspects of this, let's do this at the federal level. If this is a national security issue, we've encouraged them to do that. We've even thrown out the idea to introduce a resolution supporting some of the measures that are in Congress. That's not the direction that they decided to go in this case. The only other point I would like to say is that we've cited data about all of this foreign land ownership in the state of Kansas and across the United States of America. I actually, during the campaign, when the Attorney General brought this up as an issue, I looked at that data and found that Ellsworth County, where I live, 123,000 acres are owned by foreign entities. I was concerned. That's 6 townships. 6 townships in Ellsworth County. I've lived there my entire life with a few years where I lived in Maple Hill and Topeka during school in the beginning of my professional career. I can tell you there's not 123,000 acres owned by foreign entities in Ellsworth County, Kansas. I'm related to most of them. I do have some relation in Canada, and they don't own any land. The question I have is that's bad data. What that is, that's called wind leases. They're required to report to the USDA that they're owned by foreign entities, or there's an interest owned by foreign entities. So I guess if we're going to operate on bad data to create bad policy, I think at the end that creates bad politics. And I would encourage you now to vote no against this bill. I'll stand for questions.
Thank you. We will hold questions for our neutral conferees till we hear from our second neutral conferee, Kimberly Jenkers-Vadi, Public Policy Director, Kansas Power Alliance, or it's Mr. Swati. Go ahead, please introduce yourself and welcome to committee.
Thank you, Madam Chair. I am not Kimberly, I'm Josh, and to channel my inner Taylor Swift, it's me. I'm the problem, it's me. I'm here to present information about the wind energy and the Advanced Power Alliance. We're happy to be here. But it was teed up by the previous conferee. I want you to all understand where this data is coming from. So within the United States Department of Agriculture, there is a federal act called the Agricultural Foreign Investment Disclosure Act. It was passed in 1978. When they passed it in 1978, they exempted oil and gas leases for good reason, because oil and gas leases really don't influence your ability to continue practicing agriculture on that land. Fast forward maybe 30 years, and we have the beginning of wind leasing, largely through the Midwest, but across the entire country. Well, AFIDA says that you have to report an ownership interest, but it also says you have to report a lease interest that is longer than 10 years. So after your leases extend beyond 10 years, you have to begin reporting them under AFIDA as well. A lease is not an ownership interest. I'm going to pause. I'm going to give a little silence. I'm going to say it again. A lease is not an ownership interest. I have screamed to every reporter I know to report it this way, but AFIDA presents the data to USDA, and it has shown this explosion of foreign interest, and they say, oh my gosh, 35 million acres are now owned by foreign entities. That is not correct. These are largely wind leases, and they have started to report around 2017 or 2018 or 2019 because they started leasing in earnest around 2007. So I make no comments about the policy side of this. I'll leave that to this committee. But I do think, back to the previous conferee, this national conversation has been happening because of USDA's AFIDA report and the fact that it's being incorrectly reported and misinterpreted around the country. And the simplest solution, in my opinion, is to have Congress relook AFITA and exempt wind leases just like they did oil and gas. And you'd find out that there's actually very little foreign ownership of land, and most of that are Canadian interests in forests in Maine and Washington. And with that, I'd be happy to stand for questions at the appropriate time.
Thank you. You will have in front of you committee neutral written only testimony from Joseph Molina, Director, Legislative Services, Kansas Bar Association. Are there any other neutral conferees in the committee meeting room or on WebEx? Seeing none, then we will open it up for questions for our neutral conferees. Any questions? Seeing none, then want to make sure, are there any other proponent, opponent, or neutral conferees in the committee meeting room or on WebEx? Not seeing any, then we will close the hearing on Senate Bill 283 and thank the conferees for their testimony and their appearance in committee today. Committee, we do have some time to work bills previously heard, and we will turn our attention to that. Please stand at ease while we bring those up and get those ready. Thank you. Committee, thank you. We will open for working Senate Bill 258. And if you'll recall, that bill is enacting the Act Against Abusive Access Litigation to create a civil action for determining whether litigation that alleges any access violation under the Americans with Disability Act or similar law constitutes abusive litigation. We did hear that Monday, March 6th. Do we need Senate Bill 258? Does anyone need a brief from the reviser? Senator Stephan, yes, please, a bill brief from the reviser.
Madam Chairwoman, Jason Thompson again. So you'll recall 258, as you were describing, is the bill about abusive access litigation. It would be a new section of law that provides for a civil cause of action that either a private person or the Attorney General could bring that challenges a suit brought that alleges an access violation under the Americans with Disabilities Act or similar law. You would bring an action challenging that suit as an abusive litigation. And if you succeeded, you would get your costs and attorney fees, and that could affect the access litigation that was filed that is found to be abusive.
Thank you. Committee, are there any amendments? Senator Wilborn.
Yes, Madam Chair, I have an amendment.
Will the reviser pass that out? And would you like the reviser to explain?
Yes, I would. Thank you very much.
Thank you.
All right, thank you again, Madam Chairwoman. So, and Vice Chair, this is labeled proponents. This comes to you from some of the proponent conferees. It would add a new purpose statement. This was discussed in the testimony. I won't read all of that, but it essentially pulls a lot of information from the Kansas Act Against Discrimination and describes the purpose of this bill to maybe give some context and background if it were, usable in court. Generally not a big fan of purpose statements, but in this case, it's what is desired and it's presented here. Then the other boxes are adding factors. So this is under subsection B2, where you filed your action alleging that the civil suit filed against you is abusive litigation. So we're in the suit challenging the other suit as abusive. And these are the factors that the court is going to use to determine whether that other suit is abusive. And this would add the number of full-time employees employed by the defendant and the resources available to the defendant to engage in the litigation. It would also add whether the filing party or counsel filing the litigation is a resident of the state or is licensed to practice law in this state. And it would add a caveat to one of the factors about settlement discussions, just saying that the application of that information shall only be used as provided in this section and shall not otherwise alter the rules of evidence applicable. And then on the final page of the bill, it would add one last factor, whether any factors under KSA 60-211, which is our rules of civil procedure, exist in the litigation and whether sanctions are appropriate under that statute. For the lawyers on the committee, those are the sanctions that can be given to you if you file an action that you shouldn't have, essentially, is what that's for. The other two boxes on page 2 are a provision allowing the Attorney General to determine that litigation alleging an excess violation is not abusive and provide that written determination that could be attached to your petition. That would create a rebuttable presumption in this second litigation that your first litigation is not abusive. So that's what that box would do. And then the final box, the new subsection E, would require the court to review their determination about the abuse of litigation and any award of attorney fees under the rules of professional conduct, and to weigh heavily the results obtained in the access violation litigation. So it would just be required one final look by the court at the conclusion of the litigation to see if they were correct, that it was abusive, that it was not successful, and that the attorney fees should still be awarded and were reasonable in light of that decision and the other action. I think that's it.
Committee questions for the advisor. Senator Corson.
Thank you, Madam Chair. The step where the Attorney General determines in writing that the litigation alleging an access violation is not abusive, is that a mandatory step, or is that just something that a plaintiff may do if they so choose, or is that required?
Madam Chairwoman and Senator, it just says if the Attorney General determines that it is not abusive, then it triggers a rebuttable presumption. So I don't think by the terms of this, you're required to file it. I think you're probably not maybe being the most competent attorney for your client if you don't go seek that, right? If you're filing access litigation and you have the opportunity to get the AG to sign off and say it's not abusive and protect your client from these other suits, you probably should do that as a good lawyer, but it's not required, I don't think. And I also don't think it's required that the Attorney General do anything, that there's no mandatory review by the Attorney General. It's just an if. I think it's all permissive.
But the Attorney General does have, they can't just sit on it, right? If you do submit something to the Attorney General then does have to make some determination, right? One way or the other. It doesn't, do we need to clean that up, I guess I'm wondering?
Madam Chairwoman and Senator, it was a point of discussion in the conversation. At this point, it's just very open. You would ask the Attorney General for this determination. You might have to hound them to do it. You might have to make repeated requests. They might do it automatically and easily. We don't have anything in the statute. But so if that's something you'd want to add, we could go down that road.
My second question would be, we still even under this amendment could have this bizarre situation where you could have because now we have two separate proceedings going potentially, right? So we have the initial lawsuit that was brought by a plaintiff alleging an access violation. And then we have this claim under section, I think it's section the section saying that it's essentially frivolous litigation. So you could prevail as a plaintiff on your initial claim. You could win that claim, and there could be a finding that you did suffer an access violation. And then you could also then, in that second proceeding, have this bizarre result where in the second proceeding, the result is that you brought abusive litigation, because they're completely separate proceedings. And to me, that just seems like really problematic, anomalous result that we don't want to set that up.
Is there a question there?
Yeah, that's my question is, does this still allow for that situation to occur? Because I think that's very problematic.
Madam Chairwoman and Senator, I'm trying to answer delicately here. There are two separate actions. I agree. The amendment at least attempts to add in factors that would look at that other litigation in a light that if you succeed in that litigation, you're more likely to be found not abusive. I think that's the purpose, and I always hate to speak to purpose because I don't care necessarily about the intent or the purpose. I try to get the words right for you. I think what this is trying to do is to say you look at the factors in the Civil Procedure Code, you look at the outcome of that litigation, and you use that to inform your decision about whether it was abusive or not. That's what they're attempting to get toward. Whether that satisfies your concern that they're too disconnected, I can't say. But I think for the proponents, at least, they're saying this makes the two look at each other more. So you're looking at the two cases and trying to decide, is it really abusive? And even at the end, you look at it again to decide, what happened in that litigation? What award did I make? And would I still award that?
So that probably brings up the even better question that I should have asked at the beginning, which is, does this then contemplate that I have to wait until the outcome of the first proceeding, the access litigation, is finalized before somebody could before you could make a determination of whether or not it was abusive or not? So do we have a time issue where you can't decide those concurrently? You may not know. So what you're saying is you may not know if it's abusive until you have a final outcome in that first initial proceeding. And do we want to set that up? That seems problematic as well.
Madam Chair and Senator, and so I think the bill still allows the action to be filed concurrently while the other action is going on, or even, it has to be filed, right? So you're alleging that something filed against you is abusive, and the court is allowed to make that determination before that other action is over, especially because that action may never be over, depending on the action. But I think the new subsection E is just saying at the conclusion of that other litigation, the court has to review its determination. So to me, that says you can make the determination and you can make your award, but it's subject to a review at the conclusion of the other litigation.
I mean, it just seems
Thank you.
crazy.
We're going to move on, Senator.
Okay.
We have other questions from Senator Haley. And
Thank you, Madam Chair. Mine is really a brief comment. We're speaking more to the substantive points as you were previously. Mine was for the procedure in the opening section 2. It more reads like a whereas clause. I mean, it's not speaking to the law. There was the debate back and forth as to which direction in that same section that this legislation would go. I'm just not accustomed to seeing the debate for the justification for or against having legislation put into the wording of it. It reads, I would think, more like this should have been whereas, and then to come to the conclusions for what the law would be. And I just didn't know how the reviser reached the point of the draftsmanship procedurally to bring it in that form, which is not customary. Just a comment on that, given the time, Madam Chair, and just thank you.
thank you. Committee, other questions for the reviser? Not seeing any other discussion on the amendment. Yes, Senator Corson.
Well, sorry, not a question, but if we're going to discuss, I'm saying I'm not supporting this amendment. I think we've uncovered just in a few minutes a ton of flaws with this amendment. I think this is just not ready for prime time, and I'm not going to be supporting this amendment. I think this is very problematic for a multitude of reasons and has all sorts of unintended consequences that we've in 5 minutes barely scratched the surface of. So I will be voting no. Thank you.
Committee, other discussion on the amendment? Seeing none, then we do need a motion on the amendment, and if there's a second.
Madam Chair, I so move this amendment.
Is there a second? Senator Steffen. Committee, you have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Committee, other, yes, concerns or discussion? Senator Steffen.
I do have an amendment, and I had given it to Mr. Thompson. I think we've done a very, very nice job of delineating what a nuisance lawsuit is at this point in time. But I think the real opportunity to dissuade these sort of suits is through the attorney's fees. And so my amendment basically on page 2, line 7, changes the word may to shall. I think that ultimately, at this point in time in this bill, there's no question as what an abusive litigation is. And I think the low-hanging fruit on discouraging these is now putting these attorney fees back on the entity bringing the suit. So,
Committee, discussion on the amendment. Not seeing any, then we'll need a motion on the amendment and a second if there's one. Senator?
I make the motion that we adopt this amendment as stated.
Thank you. Is there a second? Senator Baumgartner. Thank you. Committee, you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. We are back on the bill. Yes, Senator Corson.
Thank you, Madam Chair. I have an amendment. If Mr. Thompson could distribute it.
Senator, would you like to explain or have the reviser?
I can explain it. The big change is you'll see a purpose statement there, but the big change is this is narrowly tailored to just websites, which is the problem that we heard. And I think that that's a better approach than a broad brush that I think will have a real chilling effect on plaintiff's ability to assert actual real access violation claims. I think we're better off to really focus on websites. That's the immediate issue in front of us. That was what was brought forward by the proponents. And this would address, if you think back to that gentleman from McPherson, this would address his issue. And so this would allow us to be narrowly tailored. We're addressing the problem in front of us, but we're not doing something that's going to be overly broad and have that chilling effect that I think that we want to avoid. If other issues pop up, we can always come back and address those issues at that time when that evidence is actually presented. But this allows us to do the immediate problem. So with that, I would stand for any questions or move my amendment when it's appropriate.
Thank you. Committee questions. Senator Wilborn.
Thank you, Madam Chair. I'd like to ask you a couple of questions. One is this 15 or less full-time employees. You know, I represent a relatively rural district, but I have a number of businesses like hardware stores that have 25 employees. This really limits it. Number two, you talked about limiting it to the website. You know, you get pop-ups at the gas station, you get pop-ups on your Facebook, you get pop-ups on your phone. This is much wider spread than just website. Yeah. Any response to that?
So
Senator Corson.
Thank you, Madam Chair. So on the 15, I came up with that because that 15 or fewer employees aligns with Title I of the Americans with Disabilities Act, which is why I suggested going with that number. I would say, though, I would be glad to get rid of the 15 if that would assuage the senator's concern, I'd be glad to drop that and move forward with the rest of the amendment. I think he brings up a good point. So I would be glad to concede that we can get rid of 15. And I would say, to the extent it's that we're seeing other problems again, I think that those probably need to be litigated first. There may be actually some legitimacy behind some of those claims. We didn't really hear anything from the proponents on specifics around these other issues that the good senator raised. I would be welcome to hear testimony and something we can look at in the future. But some of what he describes may in fact be very valid access claims if the pop-ups are preventing somebody from, say, using a gas station or other accommodation. So we don't know that they're necessarily not valid claims at this stage because we don't have anything before the committee on those. So I hope that was helpful. Thank you.
Yes, Senator Wilborn, and then
Thank
Senator
you again,
Stefan.
Madam Chair. Just a response to the remarks that were well founded. The previous amendment did address the employer size as a factor, and that was adopted. Thank you.
Thank you, Senator Stefan. Did you have a question or a comment? No, Senator Baumgardner. Thought I saw your hand. Sorry.
You did, and thank you, Madam Chair. Could the revisor share with us? I noticed some commonalities, like the balloon D on page 1, but where else are these the two amendments, the one that we've passed already and the one that's before us? Can they coexist or are they exclusionary? And I guess I'm really curious to see from that Venn diagram on number 2 of page 1 how they differ and how they're similar.
Madam Chairwoman and Senator, I can tell you the purpose statement in the big box on the first page is very similar. I think the word website is in there a time or two, and that's probably the only difference. The other changes, I believe, are all compatible. Whether the maker of the motion would want those same amendments in addition to these amendments is a different issue. But if you pass both of them and ask me to put them together in a report, I think I could do that with minimal conflict. And then there might be some tweaking that would need to be done. But as the senator making the motion said, the big change is to add website throughout the bill, and that would be consistent with what you've already done.
Does the amendment address only litigation concerning websites? And it would be only websites. Is that correct?
Yes, Madam Chairwoman. So the limitations would provide that an action could be filed because you're subject to litigation that alleges any website access violation, and then uses that terminology throughout. So the access violation that's alleged is based on website access.
And website access only. So this amendment is more narrow than the first amendment that got onto the bill. Is that correct?
Yes.
Thank you. And it doesn't address the hardware store owner or the pop-ups on the gas station pumps and other issues. Committee, other discussion or a motion on the amendment and any second? Senator, are you ready to move your amendment?
I am, Madam Chair. I would move my amendment.
Is there a second? Senator Haley. Committee, you have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion is lost. Yes, division has been called for. All those in favor of the amendment signify by raising your hand. All those opposed signify by raising your hand. The motion fails. Thank you, committee. We are back on the bill. I want to pause working this bill and open for working uh, House Bill 2016. And I want to move House Bill 2016. We had a hearing, and House Bill 2016 is a shell. We moved the contents of House Bill 2016 out into another bill. And I want to move that we put the contents of Senate Bill 258 as amended into House Bill 2016. Is there a second on that motion? Senator Steffen. Thank you. Committee, any discussion? Seeing none, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. Is there a motion regarding House Bill 2016 as amended? Senator Wilborn.
Thank you, Madam Chair. I would like to make a motion to move House Bill 2016 as amended out favorable for passage.
Before I ask for a second, do we want to make this a Senate substitute for House Bill 2016? Would that be a motion that Senator Wilborn would withdraw his motion and make that instead?
Madam Chair, I withdraw my motion until we get a determination. Thank you. For 258.
Well, it's the, yes, Senator Wilborn.
Yes, I'd like to make a motion that we have a House substitute for 2016.
Senate substitute for House Bill 2016 is the motion. Is there a second? Senator Gossage, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Senator, would you like your no recorded? Committee, we will now turn to working House Bill 2293. Just a minute, committee. Stand at ease, please. Committee, I hear that we will need to be working that a different day to allow some possible amendments to be worked out. And with that, then we will turn to working House Bill 2350. House Bill 2350 is, just a moment. Is creating the crimes of human smuggling and aggravated human smuggling and providing penalties therefor. Committee, we heard that bill Wednesday, March 15th. Does anyone need a bill brief from the reviser? Senator Steffen, if we could get a brief bill brief. Thank you.
Thank you, Madam Chairwoman. So House Bill 2350 is the human smuggling bill that came to you as amended by the House Committee. It provides a new crime that defines human smuggling as intentionally transporting, harboring, or concealing an individual into or within Kansas when the person knows or should have known that the individual is entering into the country illegally, benefits financially, or receives value, and knows or should have known that the person being smuggled is likely to be exploited for the financial gain of another. It also defines aggravated human smuggling, that involves a deadly weapon, causes bodily harm, causes commission of further crimes like human trafficking, and sets the penalties at level 5 and level 3.
Committee, questions for the reviser? Seeing none, is there any discussion on the bill? Senator Baumgartner.
Thank you, Madam Chair. I have an amendment.
If the reviser could distribute that, please. And would you like to explain the amendment or have the reviser?
I will, after the reviser passes it out. I will let the reviser explain it. I will simply say this is the amendment that was made at the request of Representative Carrie Barth, and it was spoken to during the hearing.
Thank you.
Okay, Madam Chairwoman, and Senator Baumgartner. So this, yeah, I think we labeled this Attorney General because it was also the Attorney General's discussion. So Representative Barth and the Attorney General, I believe, were in agreement on this language. You can see it strikes most of the language in subsection A1 and replaces it with something closer to what's in federal law, as I recall. So human smuggling is intentionally transporting, comma, then you go to the box, moving, concealing, harboring, or shielding from detection an alien with knowledge or reckless disregard of the fact that such alien has come to, entered, or remains in the United States in violation of the law. And that would be it for A1. A2, aggravated human smuggling, is human smuggling that, and then you'd strike everything up until causes the individual being smuggled to become a victim of a sex offense, human trafficking, or causes them to commit selling sexual relations. So that would be shorter and only encompass smuggling that leads to the individual becoming a victim of those offenses or committing those offenses. The penalties would still be a 5 and a 3. And then there'd be a new provision that subsection A will not apply to transporting, moving, concealing, harboring, or shielding an alien that is expressly permitted by federal law, or it would not apply to a religious denomination. And essentially all of that talks about someone who's here in the vocation of a minister or missionary for the denomination. That's also taken from federal law, is my understanding. And then the new subsection D makes a specific note that the determination of whether someone is here in violation of the law is made by the federal government under the 8 USC provision that's cited there. And no state, county, or local law enforcement officer shall independently determine whether someone is here in violation of the law.
Thank you. Committee questions for the reviser. Senator Stephan.
Thank you. This is the AG's amendment, correct?
I believe that's correct. Senator Baumgartner.
Well, yes, and Madam Chair, I saw that we saw what had been handed out at our place, and this is the work of the reviser to accommodate the information that's here. So that's why you'll see section 1 is a bit improved based in comparison.
Thank you. Senator Haley.
Thank you, Madam Chair. Just definitions. Do we have any other definition, Mr. Thompson, of the words individual and the word alien? Or is there federal terminology for that? Are there distinctions made either in our law of the definition of, quote, alien, unquote, and versus individual?
Okay, Madam Chairwoman, Senator. So I will say, first of all, that you will notice a big difference from the AG's markup and our markup. The biggest reason being we put the crimes together in our criminal code, right? We don't have separate aggravated and regular crimes. So that's the main difference, but we also just cleaned it up. But otherwise it should be what they asked for. With regard to the term alien, you've got the wrong Jason in some ways, because Jason Long in our office usually handles the immigration issues in Fed and state. But I do know in our subject matter that we have a couple of provisions in the criminal code that talk about an alien illegally within our territory. That language is drawn from federal law, just like this law would be. So I'm comfortable that at least we have a couple of crimes that would use similar terminology. And in this particular case, That determination and that definition comes from federal law, and it's made by a federal government official. So there shouldn't be anyone in Kansas that has to decide, is someone an alien or not. It would all be done under federal law only, and that gives me a little more comfort as the drafter as well. I don't know if that offers the senator more comfort, but that's why I was okay with using that phrase here.
Well, it doesn't offer me more comfort, but it does explain it. I thank you.
And that determination that would be made by federal law, would that be our state district courts making that determination, or would it be a federal administrative law judge, or who would make that determination?
Madam Chairwoman, my recollection from the testimony is that what is triggered by citing 8 U.S.C. 1373 is that the ICE agency, Immigration, Customs, and Enforcement, they make that determination. So that it would be a determination made by the federal agency that's in charge of making that determination.
Would that determination hold up our state district court in prosecuting these crimes? Do we know that?
Madam Chairwoman, I don't have any information on that. I recall from the testimony that it's routine that law enforcement is asked to make these contacts, and that, you know, the federal government is supposed to answer in a timely way, but I couldn't speak more than that.
Thank you. Committee, other questions? Seeing none, then would you like to move your amendment?
Madam Chair, I move my amendment.
Is there a second? Senator Steffen. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Is there further discussion or a motion? Senator Baumgardner.
Thank you, Madam Chair. I move we pass out House Bill 2350 as amended favorably for passage.
Thank you. Is there a second? Senator Steffen. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. With that, committee, then, thank you for your attention today, and thank you for those following along in the committee meeting room and on WebEx. Please also be prepared to work bills tomorrow that we have previously heard, so please be getting amendments ready, and look for a revised agenda to come out later today for the rest of our week. And with that, then, thank you also to our staff for their hard work and their attention today. And with that, then, we are adjourned.